Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Hello, Peter. Nice to see you again. Something to discuss this time. Obviously, there's always something to discuss, but quite a lot to discuss. And what I mean by that is we waited a long time for a judgment in the case dealing with Section 105 of the Tax Administration Act. The hearings were extended over 2 days, and there were five taxpayers involved, and it was heard on the 12th and 13th of August last year. And one thought, oh, this is taking a long time. But when you read the judgment, you can perhaps see why. So what Peter and I are going to try and do in this podcast is to make it reasonably simple and accessible. It's not that it isn't accessible, but it's the judgment extends to 150 pages, and there are a lot of points. So we're going to try and keep it relatively simple. And Peter, if you want to kick off, and then I'll...
Thanks, Trevor.
For some
Absolutely. As you said, it was quite a judgment in terms of length. Warning: do not print that on your home printer.
Yeah.
But just to remind everyone what Section 105 is about. So Section 105 of the TAA says that a taxpayer can only dispute an assessment or decision through the tax court process unless a high court otherwise directs. So in other words, 105 says you're stuck in the tax court process. You can't go to the high court unless you get a direction from the high court that you can be heard by the high court. So that's 105 in a nutshell. And one of the court's many findings is that the effect of Section 105 is that it conditionally suspends the high court's jurisdiction. So, which makes sense. You can't come to the high court unless you get the Section 105 direction. And I think there was a little bit of carefulness around this conditional suspension, because of course, Trevor, when you think about the constitutionality of Section 105, you kind of wonder a bit about that piece, and that was argued, and it was dealt with a bit in the judgment, but it wasn't a reason, it wasn't part of the sort of rationale for any of the decisions taken by the court. So I think the statement that 105 conditionally suspends the High Court's jurisdiction is quite carefully chosen wording. And just to remind everyone, kind of the two main avenues to approach the High Court in a tax matter are by way of a review or a declarator. And a review, you can either go PAJA, which is Promotion of Administrative Justice Act, or you can go Principle of Legality. And the Promotion of Administrative Justice Act is an administrative review. So you show, for example, that a decision that was taken by a SARS official was arrived at without regard for the relevant considerations or having regard to irrelevant considerations. And a legality review is more review on the basis that the decision maker acted outside of their powers. And a declarator is something that deals with a pure question of law on which the court's asked to adjudicate. Important that in respect of both reviews and declarators, it must only be issues of law and not of fact. And so going back to the judgment, the court held that Section 105 applies to both reviews and declarators, which is important. And it also importantly says that there needs to be an assessment for a decision, but principally an assessment, in order for Section 105 to find application. And that was relevant in one of these cases, Leuven Metals, where there was a declarator requested and there hadn't been an assessment yet. And so Section 105 just didn't come into play. You can go straight to the High Court. You don't need a 105 direction if there hasn't been an assessment. So I think that's interesting and important. And then something we have discussed in the past, Trevor, and I'm pleased to say that we came out on the right side of this debate, is that there's now been quite a long line of cases through the SCA, in particular upper resources, where the SCA has developed this test of exceptional circumstances in the context of Section 105. So basically saying, if you want to come to the High Court and you want a direction in terms of Section 105, there must be exceptional circumstances to move away from the tax court process and into the High Court process. And the court disagreed with that approach. It disagreed that the exceptional circumstances test was clear from the language, context, and purpose of Section 105. Of course, that's how you review legislation. That's how you read legislation and test it. You look at the language, context, and purpose. And the court mentioned that this exceptional circumstances test is expressly used in Section 7 of the PAJA in relation to a PAJA review. So there, if you go for a review under PAJA and you haven't exhausted your internal remedies, there need to be exceptional circumstances why you come to the High Court. So the court said that's a PAJA test. It's not a Section 105 test. And the court said, let's look at the language. And in the language, there's the words exceptional circumstances do not appear. So you have to read them and you have to imply them. And you can only apply words or read words into a statute by implication if it's necessary, in the sense that without it, effect couldn't be given to the statute as it stood. So it needs to be necessary that you read in the words exceptional circumstances in order to make Section 105 workable. And the court held that Section 105 was perfectly workable without adopting this heightened exceptional circumstances test. And the court instead said, if you want to have recourse to the High Court rather than the tax court, the question is whether that is appropriate. Or put another way, whether there's good cause to approach the High Court rather than the tax court. And what a lovely way of putting it. You know, Trevor, we have had some words around this exceptional circumstances test in the past. And I think this description of it must be appropriate or there must be good cause, I think, you know, frames it correctly and makes a much lower bar for review and for approaching the High Court.
If I can just interrupt, if I remember correctly,
Of course.
the point was also made that the term exceptional circumstances, that phrase is used in the Tax Administration Act, but not in Section 105, which means it was deliberately not used.
Yeah, which again makes complete sense. And there'd been a long line of cases now before this judgment, and all SCA judgments with Ponnen, I think, sort of leading the charge in the upper resources where this exceptional circumstances came up. And then, of course, the hard part was trying to find out what exceptional circumstances is, and some of the courts tried to sort of describe it in various ways. And okay, you've got a lovely, you know, threshold which is appropriate or good cause, and you don't have to try and define that, you know, because people know what that is. You just make your case. So, in summary, the test for granting a Section 105 direction is not whether exceptional circumstances are present, but whether there's a justification for departing from the default remedy, which is going through the tax court. And that justification can be tested by asking whether the departure is appropriate or whether there's good cause for such departure. The other point or another point that was made by the court is that the question as to when and how a Section 105 direction should be adjudicated is that it's a threshold issue. So that means that Section 105 prohibits an approach to the High Court unless you've got your Section 105 direction. So it's a threshold issue. It means that it's something that you have to do before you go to the High Court. You have to do it right at the start of your matter. You need to go and apply for this direction, assuming, of course, that you need the direction, and you need the direction if you have an assessment. Only if you have an assessment. If you pre-assessment, you don't need to go Section 105. But there was some, I think, description in the case as well about if you come too early, you might be seen as jumping the gun. Why are you trying to approach the High Court? There hasn't even been an assessment yet. So I think if it's a bit of a balancing act. If you've got an assessment, you need to go for your 105 direction. If you haven't got an assessment, you don't. But then you might be taking a chance that you jumping the gun in a sense by going to the High Court as opposed to just following the tax court process up to at least the assessment level or stage. And I think those were some of the points I wanted to chat about, Trevor. I think you've got a couple as well.
Yeah, yes, I've just made a couple of notes here. It's quite clear from the judgment that the judgment was obviously dealing with reviews, PAJA reviews, where you have to exhaust your internal remedies first. And it emerges quite clearly from the judgment that the court regards an objection as an internal remedy, but not an appeal to the tax court. And I seem to remember that in the Erasmus case, the High Court actually considered that an appeal to the tax court might constitute an internal remedy, or even went further than that. And it's clear. And I had an experience donkeys years ago, long before the amended Section 105 came into force, where a learned judge spelt it out that an appeal to the tax court is an internal remedy. It was Judge Burns-Ward, which maybe explains the fact that he considers that the tax court is not a court of law. But so fairly subtly, but in a number of contexts, I think Judge Rogers has made it clear that an objection clearly is an internal remedy, because you're referring it back to SARS, the same people who made the decision in the first place, but not an appeal to the tax court. And if I can just refer to what he said, since a Section 105 direction was only needed if an assessment had already been issued, a factor that would be relevant to both review and declaratory cases was whether the taxpayer had lodged an objection to the assessment and whether the objection had been disallowed. In a review case, the process of objection was an internal remedy for the purpose of Section 7.2 of PAJA. And I don't think I need to take the point any further than that. One of the tensions when one wants to approach the High Court is the question of piecemeal adjudication of a legal dispute. And if I can just refer to what the court said here, the court said the following: an important factor that might arise both in review and declaratory cases was judicial aversion to piecemeal adjudication. Where a taxpayer wished to pursue a review or declaratory case in the High Court while also pursuing other grounds of appeal in the tax court, there was an obvious danger of piecemeal adjudication. The tax appeal might need to be held in abeyance while the High Court proceedings were finalized, and obviously the court referred to an inherent judicial disinclination to have two adjudications going on at the same time. If the substance of the point that the taxpayer wished to pursue in the High Court could be adjudicated in the tax court, the avoidance of piecemeal adjudication would be a powerful factor against giving a Section 105 direction. If all the issues were before the tax court, that court to decide how best to manage the litigation and whether it should allow any particular point to be adjudicated separately from others. So if that's just one aspect that taxpayers, if they are wanting to approach the High Court for a Section 105 direction, must bear in mind. The court referred to the role of the tax court as being a curative remedy, whereas the role of the High Court would be a review remedy. And so, that's the tension, and the circumstances might favor the one over the other. Perhaps it should be said that the first 130 paragraphs of this judgment is of general application, and there's a lot of sage and good, it's not advice, but it's general treatment of the principles involved as to when one is likely to succeed when someone is likely to succeed in obtaining a Section 105 direction and when one is not. So one has to be aware of these tensions, because very often, because the tax court has the power to substitute its own decision for that of SARS. That's why it's called a curative remedy. So if there's been a defect, even an administrative defect, if SARS can come to its own decision on the facts, then that can cure that defect, and it might not be necessary to go for a thing. Another aspect is whether the dispute turns on a pure point of law. And does that justify a Section 105 direction in favor of direct access to the High Court? Again, there's no clear-cut answer to that. Certainly the fact that something is a pure point of law might be of assistance in going direct to the High Court. But I think what comes through the judgment is that there might be a pure point of law, but there are also other points, and those other points will have to be determined in the tax court. That makes it less appropriate to try and go to the tax court. And the court made the point that, yes, if the pure point of law is determined in favor of the taxpayer, that might resolve the whole issue. But if it's not, then it might be determined in favor of SARS, and then you have to go right back to the tax court and go through that whole process. What was the expression you referred to last time? A protracted slog through the tax court.
Yeah. Long and protracted slog through the tax court. Yeah. And that is Judge Sutherland on the Absa case.
So if one is contemplating trying to go direct to the High Court, I think one has to read through these 130 paragraphs and just see when it's appropriate and when it's not. Another interesting aspect which the court referred to is the question of time barring. And if I can just mention what the court said, and this is like a paraphrase of what the judgment says. If an additional assessment was set aside on review, Section 99, which is the prescription section, or the limitation of, what's it called, the period of limitations, might give the taxpayer a time bar defense if SARS were to issue a fresh additional assessment. In this situation, the possibility of a time bar defense against a fresh additional assessment should play no part in the court's assessment of whether or not to grant a Section 105 direction. In other words, it should be irrelevant. The lawmaker could hardly have regarded it as appropriate for a direction to be given to pursue a review merely to take advantage of a time bar provision. If there were other reasons that made it appropriate to give a Section 105 direction, the fact that a successful review might present SARS with a time bar problem would not be a reason to withhold the direction. But conversely, if there were no other reasons making it appropriate to give a direction, the fact that a successful review would give the taxpayer a time bar defense against a fresh additional assessment would not justify the granting of a Section 105 direction. So there's a lot of it depends. And if I can just end my remarks by giving my, this is my own opinion on something. If one looks at the way that the court dealt with the five disputes before it, and by the way, sorry, if I can just go back, we referred earlier to a pure point of law. The court emphasized that one must analyze the situation properly and make sure it is a pure point of law, because the court disagreed with the Supreme Court of Appeal in the Absa case that there was a dispute of fact. So it's not always that clear cut. But as a general comment, it seemed to me that the court, if you look at the outcomes of the various disputes, there were 5 cases, and 2 of them lived to fight another day. And I think the sense I get is that there's reason to be optimistic in both of those cases. And the other 3, that's it. It's the end of the road. And if I can read between the lines, I think the court had regard to the merits of the appeals in deciding who's going to live to fight another day and who's not. like for example, in the forged packaging case, they clearly were not with the taxpayer on the merits, and that made the decision easy. So the merits, it seems to me, do play a role. I don't know if you have anything to add to that, Peter.
I think it's very interesting, Trevor, and it makes sense. And I think you can read that into the judgment as well. Like if you look at the ABSA case, which was a review, and the High Court, as we said, Judge Sutherland found in favor of ABSA in respect of the 105 direction. So ABSA got the 105 direction. And the Constitutional Court held that was correct. It said the High Court should have considered the risk of piecemeal litigation, but the High Court's decision was not manifestly inappropriate. So ABSA succeeded on that, and then so that means ABSA is going back to the Constitutional Court on the merits. And their case was that Section 80J case where ABSA said we're not a party to the transaction and we didn't get a tax benefit because there was some tax structuring done, but it wasn't done by us. We just invested in preference shares. So, and I think there, Trevor, to your point, is that it sounded like Judge Rogers might have been a little bit with ABSA there, and sort of there was some hints there that he was considering the merits when he was giving his judgment. And it'll be very interesting to see whether they do come out on the side of ABSA when it goes back to the Constitutional Court on the merits on those 2 points. And those 2 points will be really interesting points of law for us. Forget about 105, tax benefit from the Constitutional Court and who is a party to a transaction in an anti-avoidance context. Are you a party just because you invest in preference shares? It's almost like, if you lend your money to the bank and the bank does something structured behind the scenes, that somehow you're a party to that. So I think you're right on that merits argument. I think that is always relevant and taken into account.
I spoke to one of the counsel who appeared for SARS, and I think it was in the ABSA case, but I might be wrong. And this person shall remain nameless, but he regarded as the subsequent hearing which is going to take place in the Constitutional Court itself. It hasn't been referred back. Is going to be a slam dunk.
we will see. And as you say, like forged packaging, we're all forged there because that was a review and they just got biffed on everything. They said the court held that there was no basis to interfere with the High Court's decision to refuse a Section 105 directive, and so that was forged are gone. Leaven metals, as I said, was interesting because that was declaratory relief that they sought, and the court held that a Section 105 direction was not required because no assessments had been issued. So the High Court correctly entertained Leaven's application. So that was good for them. And then UMK was a review and a declarator, and the Constitutional Court looked at the 105 points and refused the direction, effectively refused the 105 direction for UMK, which is disappointing. It's one of our matters. And then RUPA, the court, that was also a review, and the court said that, I think they said RUPA can enroll the matter in the High Court in terms of whether it can get a 105 directive or not. So sort of, I think that's sort of what would you call that, a draw between the taxpayer and SARS. So yeah, some interesting, very mixed results between all the cases, but as you say, it's much more about the principles and kind of, the way forward and all of this stuff after all of the raft of SEA cases that we've dealt with in the last year or two. So I think we now have a reasonable degree of clarity, choosing my words carefully.
Two points occur to me just to mention. The one is that the Constitutional Court made it absolutely clear that the tax court does not have the power to grant a declaratory order. I mean, that comes through loud and clear in the judgment. And then also the discretion of the High Court, whether or not to grant a Section 105. The courts said that was a true discretion. And what's interesting about a true discretion is that, or it's a full discretion, if that's the right term, that two parties could legitimately come to different conclusions and you can't say that it was necessarily wrong. Whereas something which is not a true discretion, then it's either right or it's wrong. But
I think that's really important.
yeah.
That discretion point, and that's why an appeal court would be loath to meddle when a lower court has exercised its discretion properly. They may have come to a different decision, but there's nothing manifestly wrong with the way that the lower court dealt with the matter. Then they won't meddle with that discretion, which I think is really important, and that helped ABSA for sure. They said that Judge Sutherland's decision was not manifestly inappropriate, so it's been covered in praise, but it's they didn't meddle in the exercise of that discretion. So I think that's important.
There's a lot of meat in this judgment, and one can see why it took 7.5 months.
And in terms of, if we're brave enough to kind of tell people what to look at going forward, Trevor, I had a couple of points here, and the one I scribbled down when you were talking, because I think that's really important, is that make sure that your matter deals with a pure point of law, and there aren't factual issues, and that is so difficult because SARS will try and wrap the law in the facts, and they'll always say there's a dispute of fact. And it is a tricky thing, but you need to make sure that your issue is just an issue of law. And ABSA may be a good example. The questions of law are, the concept of tax benefit in the context of a party. It doesn't really matter what the facts are in relation to that. That's a legal question. So I think that's a really important point of law. Second one, big victory, exceptional circumstances has been washed away and replaced by this test of appropriateness or good cause. So much lower threshold for going for high court relief. As you say, internal remedies, really important as well. That's really helpful. So if you're going to pudge a review and you have to go through your internal remedies, Trevor, as you were saying, that means you get your assessment, you object to it. As soon as the objection is disallowed, then you're done with your internal remedies. And if your objection is allowed, well, then you've got no dispute, so no issue. But as soon as
one takeaway for me is correct me if I'm wrong, but I think one can advise people always object to the assessment. Don't try to go to the high court. Haven't objected yet.
100%. Object, and when it's disallowed, then suddenly internal remedy barrier has been overcome, and then you can go for your 105. And then the point you made as well, that is the review going to be dispositive of the matter and not lead to piecemeal litigation? I think that ties into the point around, and we've debated that and wrestled with that a bit, Trevor's kind of, are you delaying the process by going to the High Court? And you and I are saying, no, you're not delaying things. You're trying to, it's dispositive of the matter. You're trying to end the matter quickly and not have this long protracted slog through the tax court, but make sure that that is the case. This isn't just a side trip to the High Court on a particular point, and then you need to come back and you need to fight in the tax court, because this piecemeal litigation, I think, was quite a big piece of the Constitutional Court's judgment. They went on about that a bit.
If I may be just a tad parochial for a moment, I was chuffed to see that in three footnotes in the judgment, the taxpayer is referred to.
Should have been way more than 3. That is good. So yeah, and it's the end of a long road, Trevor, I think they say, with it's finally come to a head, and we've got a really, really good, strong, heavyweight judgment in every sense of the word.
And we'll wait and see how it pans out in practice in the future.
100%. I don't expect there to be a flood of review applications, because there's a lot of careful. One needs to tread very carefully. I think people have been burnt in terms of going for reviews and getting biffed in terms of the 105 direction, and some of the stuff we've said earlier, Trevor, I think still applies. That some High Court judges, if the tax law is really complicated, the facts are really complicated, they might be sort of loath to deal with it on their watch, as opposed to sending it back to the tax court. So you're always dealing with those sort of softer points as well. But at least it's made it's clarified the rules of engagement, which I think is helpful, and in a way that's good for the taxpayer, I think.
Something that occurs to me now is that the court referred to the fact that in the tax court there's a protection for SARS, but also for the taxpayer as far as costs are concerned, whereas there isn't in the High Court. And the possibility was mentioned that the taxpayer could, or either party could, whichever party is seeking the direction, I suppose it would always be the taxpayer, could undertake to subject themselves to Section 930 of the Tax Administration Act. In other words, say we accept that we won't ask for costs unless SARS is being unreasonable. So it's the first time I've heard that suggested.
Absolutely. Thanks, Trevor. It's really interesting, and yeah, the end of a long journey.
Oh, yeah, and yeah, it's certainly well worth pondering it. And from publishing it in the taxpayer, what I have in mind is to break it down into 6 different parts. So the first part will be what we've discussed today, where the court discusses the general principles involved, and then each of the 5 cases. We'll see how those were in fact applied in practice. And no doubt there'll be more fun and games in the future. There always is.
There will be a lot more fun and games in the future. Thanks, Trevor. Nice chatting as always, and let's do it again soon.
Yeah. Okay. Thanks very much.
Cheers.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dax. For more information on our journal and other products, please visit our website at Taxpayer.Co.Za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at Taxpayer.Co.Za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.